Welcome to Dad Talk Today. My name is Eric Carroll, and we have an amazing show lined up for you. We are fighting for fathers all across the United States and all across the world where you can be glad to be dad. Stick around, guys. Dad Talk Today is about to begin. Hey, everybody. Welcome to Dad Talk Today. We're glad you are here. Sorry, yesterday we had to move the show to tonight. We usually do this on Monday nights, but it's good to see you again, Kevin. How you doing?
Hey, same here. Good to see you. Doing good. How are you?
I'm doing all right. Guys, we're going to be doing a live Q&A. If you got some questions, put it down in the comments, and I'll bring it to Kevin. Nothing about this creates a client-attorney relationship. We're just on here talking, but you know, Kevin, we got together the other night and talked to the family of Chad Reed. What's your thoughts on that whole situation? And it seems like it's really starting to make some noise because just a sad situation altogether.
It is, and again, it's what we talk about, that we've got to put some kind of safety measures in place. And you know, another example of, and Eric, you've noted it. You and I have talked about it. It's another example of it's hardly ever the ex that is the one that's doing this. It's either a significant other of the ex or a family member or someone else. And it's hard to imagine a time that interjecting a third party to a custody exchange was a good thing. I mean, it just doesn't bode well, especially if there's already been tensions. It's just going to escalate things.
You know, it seems like that is the common occurrence. There's always a third party there, and it's rarely ever the spouse. That should be something I would think should be sounding some bells, raising some flags right now.
Right.
I think this situation is definitely going to force people to look at it, and I'm hoping we continue to raise the awareness and everything on that. But you know, I said something earlier. It seems like this is starting to become a common scenario. Every single week we're hearing more. I was actually reading up on one. I'm waiting to get some more details on it. Seems like there was one that went down in Nashville last week. There was like a few kids that got killed in this one at the custody exchange because of the shootings. And I don't know, man. It's something that I hope we can get some awareness out there and get some solutions. Just a sad situation.
Well, I think, and you know, one of the things that I've kind of harped on is proximity. When someone's close to you, they can do some kind of harm to you. So if you've started to have real contentious custody exchanges and you're getting really concerned about your ex or whoever else is there, talk to a lawyer or something. And until we can get some legislation in place or something, you can put things in your order to try to keep third parties away and try to keep that proximity away. You know, we've talked about meeting at the police station. That helps you. Doesn't always make it, you know, nothing's 100%.
Nothing's fail safe. Yeah.
But if, let's say, mom arrived with the child first, took the child inside, and there was a place there with a police officer or whatever, and then mom leaves. Mom and whoever she's with leaves. And then dad shows up 10 minutes later and picks up the child and leaves. You know, again, it's not 100% perfect, but it what does it do? It limits proximity. It limits putting people together in a very contentious, heated situation. And you can do that without legislation. You can try to talk to your lawyer about some safeguards you can try to put in place if you've got a problem.
Absolutely. All right, we're going to get to some of these questions, guys. Again, get those questions down in the comments, and I will bring in McKevin. This one comes from Dave Murray, VIP here in the house. He said, Kevin, yeah. He said, Kevin, is CPS the only ones that can present a medical finding of abuse to a judge?
Absolutely not. You are free to create whatever kind of case you want. And if you have any medical findings, you want to bring those to court. And, you talk about a medical finding of abuse. Sometimes abuse will come out of a custody evaluation, and a custody evaluator may note that, a counselor that the children have been seeing or one of the parents has been seeing. It could be from an investigator. It could be from a police officer. A lot of different places, a lot of different professionals can make a finding of some kind of abuse, or that they think it's going on. So whether it's medical or otherwise, if you've got some kind of a finding of abuse, bring it to court, and talk with your lawyer about making sure you get that presented properly, because it could be hearsay. A report or an affidavit they've given you could be great and perfect, and you get to court, and if you don't have them there, it's going to be hearsay, and you're not going to be able to introduce it. So make sure you talk with your lawyer about making sure you can get that into evidence.
Yep. We got one here from Mr. Stephen Creasy on Facebook. He said, Kevin, what should I do on my first court date? I got mine next Friday.
Well, it's hard to say, Stephen. I don't know what your case is about, or what this first appearance is about. I would just need more information about what's going on to help you with that.
Yeah, get that down for me in the comments, and I will definitely get it back going. Dave got another question for you. He said, have you ever applied the Rule 52 plain error rule to a case? And if so, what time frame is that restricted to?
I don't believe I have, Dave, and that rule may be different in your jurisdiction. But no, I've never applied that. I'm not much help there.
Yeah. We got one out of Texas, Sarah Johnston, really good advocate. She's put in a lot of hard work over the years, and I appreciate her. She said many times custodial parents get past a geo restriction because judges do not want to restrict where an adult can move. We put our restriction on the child and a clause covering if either parent moved out of the county, they became NCP. Thoughts on this being a good position for the community to start trying to include rather than the standard restriction?
I think that's fine. And this comes up sometimes in cases where my client is concerned about the other parent is going to be moving either to another county, another state, halfway across the country, because they have family somewhere else, or they're from there, and then move to the jurisdiction where the case is now, but then they're going to go back home or whatever. So it comes up, and when it does come up, we have to have these discussions about how can we limit that from happening. It's really hard to do that, Sarah. I think decades ago you could do it, but now the courts use words like technology. It's a more mobile market and a more mobile world that we live in now. And it's just easier to travel and get different places much faster than it was decades ago. So all of that means that a lot of the court of appeals around the country are usually in favor of allowing a parent to move if they need to, they get another job or whatever. I have never been a real proponent of that. I think it just causes even more distance and divide between a family when there's already a division that's there. So we've started to talk about some of these restrictions we can put in orders. Okay, mom, if you want to leave and you want to move to Arizona or wherever, that's fine. But then I become the custodial parent by default if you're going to do that. Some judges in some states are a little hesitant to enforce those restrictions because of what we talked about at the beginning. They feel like it's a more mobile world now. There's technology with FaceTime and Zoom and those kinds of things to get virtual visitation. So they're not so hard on parents that are wanting to move now. Child custody is a decision that is always modifiable. And anytime you start to put restrictions on that, or here's what we're going to do if you move a certain distance away, the appellate courts are really going to look at that with a lot of scrutiny, because child custody is always modifiable. It's always what's in the best interest of the child, not what's in the best interest of the parent. So that's a lot of information, but I think I would summarize it all by saying, if you can negotiate some kind of a restriction like that and the other side agrees to it, that's great. And that'll help you a lot. And hopefully it'll withstand legal scrutiny if you have to have it looked at later.
Yeah. Got one in here from Crunchy Mama. She said, what's the probability that the result of custody evaluations are followed, or can the judge just go with whatever they want?
That's a real good question. I have not had, there are certain jurisdictions that use custody evaluators, and that it's basically what you're seeing here. They come in and they evaluate the situation and see what should probably happen with custody with the child or children. Usually my understanding is that judges will generally follow that and follow what the evaluation is, unless there's a lot of evidence to show that it shouldn't be followed. A lot of times in a lot of jurisdictions, and Arkansas is one of these, the ad litem for the children is the one that makes a recommendation, and they in many ways serve the role of what a custody evaluator does in a lot of other jurisdictions. So I can tell you the ad litems in Arkansas, generally their recommendations carry a lot of weight with the judge, and that is normally what the judge will do unless you can really show evidence on the other side. And that's what we do. If we get an ad litem or a custody evaluator that's in our favor, then we just want to keep, I call it, we want to keep that train on that track and going that direction. We don't want to impede it. And in fact, we want to help it keep going down that track. If you're on the other side of it and the custody evaluator or the ad litem is recommending against your client, well, now we've got to start beefing up our evidence to show that recommendation is not really what's best for this child. With all due respect, ad litem or custody evaluator, we think it should be this way. So the earlier you can learn in the discovery process kind of where that evaluator or ad litem is leaning, the better, because then you can start to prepare for court accordingly.
Got a little bit of a long one. I'm going to read it from the cell phone from Taylor Grove. He said, currently my ex is no showing court-ordered meetings with the parenting coordinator, not responding to emails, also talking bad about me, my girlfriend, and my family to my son, most notably telling him I'm not his real dad and my family doesn't love him. This has been recorded and testified to the coordinator by my son directly. My case ended in July. How long do I have to sit back and let her show a pattern before filing a change of circumstances and hoping the judge will see they messed up?
It's different in every case. And this question comes up a lot. How long do I have to wait? And usually we sit down with the client and we listen to the situation and the facts that we're hearing, what the other parent is doing, and try to get an idea of last time they were in court, what was the judge's demeanor? Was he really warning the other parent, look, you better not be engaging in this behavior or I'm going to have a real problem with it? We kind of want to know all those things because it affects how we answer the question you've got, which is how long to wait. If a lot of times when we get hired on a custody modification later, we weren't involved in the original case. So we usually ask the client quite a bit about what did the judge say? How did the judge react to your ex? Were they upset with them because of their actions? And if all those questions are answered in the affirmative, that, yeah, the judge was really upset with her or him and said it better not happen again, well, to me, that shortens the time that it takes before you need to go back. 6 months, I'll be honest, if you file and a judge sees that it's been only 6 months since you were in court, they're going to really want to see that you've got a lot of good evidence and a lot of good reasons that you're coming back to court. I know that seems like a long time, but in judicial time, 6 months is not a real long time before you go back to court.
Scott Price said, Kevin, I've hired 4 different lawyers and consulted with another 8. Only one has been frank with me. I have video of one describing to a judge how he is happy to work against his client's wishes, agreeing to a continuance. Another lawyer in my employ refused to set a meeting to review evidence I submitted to him. How common is it for family attorneys to behave this way? Call me crazy, but I expect reasonable customer service, assuming the client is reasonable.
Well, I don't see any of that. I mean, it's certainly not an unreasonable request to sit down and go over evidence. I mean, that's what we're supposed to do. And we try to tell clients, look, if we do as much as we can by phone and email, but if you ever feel like you're not getting communicated with very well, or you need to sit down with us, set up an appointment and come in and let's talk about it. I want to talk about the continuance thing for a minute. That is that's a sticky subject. As attorneys, what we are constantly dealing every day with other attorneys, and attorneys are people too, and some of them are great and some of them are complete assholes, and we've got all kinds. And so we have to deal with whoever the attorney is on the other side. And I had a really good mentor attorney that told me very early on, because I wanted to object to every continuance request from the other side. I said, look, we're ready to go to court. My client wants to go to court. And he told me, look, there's going to be a time that you're going to need a continuance, or your client's going to need a continuance. And if you screwed over Joe Blow over here and said, I'm not agreeing to a continuance, and then he happens to be on the other side when you need one, he's not going to agree to it. So it's always it's kind of a balancing act. You have to look at how long the case has been pending. What's the reason for the continuance? Is this an attorney that has worked with you in the past on continuances? And your client. And, if we've been waiting forever and ever and ever to get in court, I'm probably going to tell the other attorney, look, I'd normally agree to it, but we've been waiting forever. We've already continued it once or twice or whatever, and we just can't. But a lot of times, if we can agree to it, I usually will, because we just never know when we're going to need one. And that could be your case that we're now representing you on, that 2 years ago, I helped out this one attorney and gave him a continuance, and now you and I are needing one, and he's going to do it because I helped him back in the day. And I know when it's your case, you think, well, that doesn't really apply to me. I wasn't there 2 years ago. But in a way it does, and that's part of our profession is to try to work with each other as best we can. Now, we always try to consult with the client, though, before we do it. So I don't know really what happened in your case, Scott. You kind of got some of it here, but that's probably a little bit of what happened.
Jason Overmeyer said, I have 50-50 legal custody. My daughter has been diagnosed with multiple mental illnesses, and now her mother is receiving funds regarding these made-up illnesses. I am supposed to be notified about anything to do with medical and academic decisions. I was not involved with these decisions. What are my options?
Well, I'm trying to see. It looks like mom's getting funds for that. If they have 50-50 custody, then it seems like he should be getting Jason should be getting half of those funds to help. If there's illnesses going on and academic problems, I mean, you need to be involved in that. I would either talk with her and tell her to start notifying you, or go to the school and find out what's going on. As a parent, whether you have 50-50 joint custody or not, you have the right to know what's going on with your child in school and what's going on with them medically. So you can go to appointments. You can go to the PTA meetings. You can go to the parent-teacher conferences. You can do all of that. And unless your order says differently, you're allowed to have all that information. So you may need to start kind of asking around on your own and find out what's going on. And if mom continues to not communicate with you, you may have to take her back to court.
Yeah. Stephen re-clarified, so I'm going to read this and then I'll go back up to the top with the question. He said, get an established court order to see my daughter and to get her every other weekend, depending on what the judge says. And my ex can't say where and when and how I can have visitation and rights. What should I do on my first court date next Friday?
Well, I'm wondering if that's the final hearing. And here's why I'm a little confused, Stephen. First court date, many judges have what's called a pretrial conference. They want the attorneys to get together. The judge will want to know where you are with discovery. Will mediation be a possibility that would work? How long are you going to need for a final hearing? It's kind of an administrative thing. And a lot of times that's the first hearing you have. So if it's something like that, then your attorney is probably going to be doing most of the talking, and just kind of, it's more of an administrative thing. If this is like a full-blown temporary hearing where you're going to have these issues discussed that you've got on here, then as far as what to do to prepare, you just need to talk to your attorney and find out if they need any more evidence from you, if they need help with witnesses. And what I mean by that is, we'll sit down with the client and find out what witnesses are going to be important for your case and who we need at the temporary hearing. And many times I'll ask the client to notify those people, hey, make sure they know the day and the time to be there. Now, if they need a subpoena for work or whatever, we'll send that. That's no problem. Just let us know. So you may want to talk to your attorney about if there's any witnesses you need to notify, and then find out if your attorney needs you to testify. And if so, you may want to do a rundown of what you're going to be asked at the hearing.
Max on YouTube, he's got like a 4-parter here. He said, if your state's standard is joint custody, how long does it take to show that joint isn't working and one parent needs to be the primary for decisions? I'll let you answer.
Yeah, we'll do it one at a time.
Yeah.
Again, that goes to the severity of the problems. If you're having little issues that you can't agree on, it's going to take a longer period of time to show a pattern that this needs to change. If you've just had 2 or 3 small problems and you go to court, the judge is going to say, look, you guys go back, figure out a way to get along, and I don't want to see you back here for a long time. If you're having major problems, the other parent is starting to have financial difficulties or problems with some kind of substance abuse or neglect of the child, you're starting to get things like that. Well, now you don't need to wait so long. And you might have some kind of situation where you got to get into court sooner. You just need to talk to an attorney in your area and get a family law attorney that has experience in it and get their opinion on it.
Yeah. It seems like the rest of it, he was just saying his situation. I hope that if you got any more questions, put it down there for us, Maddox. Thomas Higginbotham on Facebook. Where we go? He said, I need an attorney. My first 2, not kidding, did nothing. How do I get a good attorney? How do I get them to actually care and not just take my money? I mean, Kevin, we've talked about this several times. I think it's probably one of the most asked questions that I get in my inbox. Who do I trust? How can I find a good one? You've been doing this a lot longer than I have. What would be your best advice to somebody, what to look for in an attorney, where to go do the research and everything on getting someone that will fight for them?
Ask friends. I don't know how open you are about your situation with other people. Ask around to your friends if they've used attorneys in the past and what their experience was. You can go to Avvo, which is avvo.com. It is a review website for attorneys. I'm trying to think of the place that came out a few years ago. Anyway, you could go there and get reviews of different professionals in your area and stuff like that. Well, this one is specific for attorneys. So avvo.com, you can go there and you will see ratings on there. You'll see reviews from other attorneys about this attorney. You'll see reviews from former clients. And that's a good starting point. You know, when you first research and say, I need a family law attorney in such and such city and state, the first thing it's going to start pulling up is Google reviews. Google reviews can be good. I'm not sure how accurate they are. Anyone can go on there and leave a star or a 0 or a whatever. I have found that Avvo is a little more specific. But I would first start kind of asking around coworkers and friends you have, family that may have used an attorney, and then maybe Avvo, and then find some attorney, set up a couple of consults with 2 attorneys in your town and say, if you were going through a divorce or you had a custody case, who would you use? Who has a good reputation in town? There's nothing wrong with that.
I think that's a good conversation too, because as much as you can research on there, guys, remember, there was 2 sides to every story. Your ex had an attorney. So if you had somebody that was doing you wrong and your ex had an attorney, there's going to be people that are not going to get the results that they wanted. and it's easy
Mhm.
to smear. How do you kind of decipher, Kevin, which ones were actually good and bad when you're looking at these reviews? I mean, do you have any advice on that?
Yeah, I think if you see someone, uh, every attorney out there, even the best in the world, has a 1-star review. So if you see a 1-star review or 2 or 3, depends on how many total reviews are there, and the rest are like all 5 stars and people that are really leaving detailed descriptions about what happened and how well they were taken care of, you can probably disregard the 1 or 2 1-star reviews. But you get a sense. It's just like a review of a product or anything else. You can tell if a client really engaged an attorney and used them for their case and what they thought about them. And most of
You'll
the
see
time, you can get a good idea. It's a good starting point. It's not the end all, but it's a good starting point.
Yeah, look for patterns. If you see, multiple people saying kind of the same scenario, um, that'd definitely be it. But again, be mindful of that, guys, because always 2 sides to every story. And if they didn't get what they wanted, you're always going to see negative reviews.
Well, and I
Uh,
will say this too: if you've used an attorney for something else, like a bankruptcy or a criminal matter or estate planning or something like that, and you still kind of know that attorney, I don't think they're going to have any problem at all with you calling them up and saying, "Hey, I've got a family law issue. Who in the area does that kind of work, and who do you respect?" Most attorneys, even if they're not in the same practice area, they know about the other attorneys that are really good in the other practice areas, because a lot of times we have to refer them to that place. So just because an attorney is not a family law attorney or something doesn't mean they can't help you with finding a good one.
there you go. A regular guy said, "Do you know what it takes to be considered a safe exchange place recognized by family law? Or is it just on the parents to agree where? I'm seeking to establish an agency with custody exchange and parental supervision. I interned at an agency that did the same under domestic violence anger management platform, but I did not ask how they established the services." That would be really good. And then we need to see these exchange.
That's the kind of, Eric, when I've kind of mentioned that before, that's what I've kind of envisioned is, and I guess it would be a business that its sole purpose is to do visitation exchanges. And no, as far as what you have to do to be licensed and that kind of thing, I have no idea. I doubt there's anything like that out there that has an agency overseeing it. But something like that, I think, could be fantastic, and I think it would cut down on a lot of the problems we're having.
I have to agree. I mean, I would even think, I mean, I'm just talking out loud here, guys. It probably set it up as a nonprofit or several other things. I think with what you're seeing going on right now, with the shootings at these custody exchanges, many people would support that idea. And
Absolutely.
is it going to completely eliminate the problem? No, but any little bit of conflict that we can decrease would be a win for this movement.
Yeah, any roadblock you can put in the place of someone that's wanting to do harm is gonna limit the chances that it's gonna happen.
That's it. Uh, Zontrail Brinson said, "Hi, my name is Zontrail. I am 21 and a father of 2. The mother of my kids took my son and left when she was pregnant with our second child without my consent. I moved there to try and fix things. It didn't work. So now I'm living in Florida. The mother of my kids won't let me see my children and is keeping them away from my side of the family due to issues we had in the past. What would be the best thing to do to ensure I can get my children to live with me, but still have joint custody?"
Well, if she's got custody, what you're talking about with saying you want to ensure that they can live with you, that sounds like a change of custody. You're going to have to show a major change in circumstances has occurred since the last time you were in court to get them to live with you primarily. I think the first step is to get in front of a judge and show that mom is refusing you time with the children, and get a visitation schedule set up if it's not already, and start getting all of your time. And it may even be time you need to talk to an attorney where you're located. It may even be time to ask for a change of custody or increased visitation at a minimum. Get more time because of the time she's been refusing you. If you have been court ordered visitation and she's not following that, you need to keep track of all the time you're losing and ask for every bit of that time back when you go back to court. Some judges will not grant that. Some will, but if you don't ask for it, you're not going to get it. So I think that's where I would start, is getting that visitation enforced and start showing a track record with the court that mom is not following the court orders.
Jason Overmeyer said, also, my daughter is doing horrible in school with horrible absences. I have parenting time for 8 days a month. Do I file for custody?
Again, Jason, every case is different. There are about 15 factors that judges look at when they're trying to decide on a change of custody. School grades, school behavior, absences from school, those are all factors that the judge looks at. And I will tell you that when a child is having emotional problems or issues with one parent or the other, one of the first things you will start to see is their grades will crater and they will start having absences. So judges are aware of that. And if that's going on, you just need to talk to an attorney where you are and make sure they know about all that information.
Holly Gager said, in what cases are family court judges exempt from immunity?
I think what you're saying is where they don't have immunity.
Yep.
Exempt from immunity. Holly, none. I slim and none. And it's the reason I'm kind of laughing a little bit. Eric and I, we get this question quite a bit, and judges are they're just immune. And I don't know what's going on with your case or your situation, but you're probably going to be better off trying to find another angle to try to attack whatever's going on.
Let me ask, Kevin, in a case that they've got these judges, they feel like they just keep coming up to a dead end. They know they've got their case. They're trying to explain what they've got going on. Judges got immunity. What would be an approach to that and trying to rectify that?
You mean where they feel like they're continuing to get negative, not getting good results with this judge?
Biased judge, they're not getting good results.
It's hard. It's very hard. And when I was talking about earlier, a lot of times when we get in a modification of custody case, we weren't the attorneys on the original case. So we get these stories about how the judge acted toward the client and was biased against them. And that's one of the first questions, can we change judges? And usually I just tell them there's not much we can do. All you can try to do is show that now that you're coming back to court, things are different, and maybe have a different approach. You've got a different attorney now, and try to present it differently so the judge can try to be as objective about it as possible instead of subjective. A lot of times I will look back at when the client was with a different attorney and they were in court before. Clients we're all human. We don't want to acknowledge our own faults about things. So I will start to see things that happened that the client made a mistake about and shouldn't have done, things they shouldn't have said on the stand that probably really alienated the judge. If I start to see something like that, then my job's going to be to try to show, look, judge, this, client's a different person now. They don't act that way. They don't say those things. And we need, custody changed or more visitation or whatever it is. So every case is different. Trying to get a judge to recuse because of bias, unless they really know one of the parties, is just really, really hard to do.
Yeah. Got a little bit of a long one. I'm going to read it here from the cell phone. Kyle Thomas Kowalski said, my daughter's mother lied to me when she first got pregnant and told me it was the guy's child that she was cheating on me with. I moved out of state and my daughter was born during that time. She was given the other guy's last name. After multiple attempts, I finally got a DNA test done and she is my daughter. Best thing ever. I occasionally get time, but nothing permanent. She always gives my daughter off to her mother or family and friends instead of letting me get constant time. What's the best route to go for me and get some sort of visitation or split custody? It's quite often I'm supposed to get her and then last minute her mother changes her mind, or her mother will message me last minute when I'm not available to get her and then hold a grudge and keep her from me because of that. Any help is greatly appreciated.
Kyle, I'm looking. I don't know that you've been to court yet. I know they did a DNA test. She told him when she first left it wasn't his child, so I'm sure he didn't file anything. he occasionally gets time. Kyle, are you getting time because mom agrees to it, or is there some kind of court order out there? If there's not a court order and you haven't been to court to establish paternity, that's the first thing you need to do. You need to be declared legally the father and get a visitation schedule set up. And then it's out of mom's hands. There's a schedule that she has to comply with.
Yeah. I'm going to touch on this real quick, Kevin, if I can. Randall Oliver said, Eric, I sent you a message about Doug Gorman. This is my brother-in-law. He hasn't seen his kids in 2 years. Is there help? If so, where? He is basically being boycotted from his girl. He needs help so bad. I've been through the court system and I've never seen it this bad. Randall, I get messages like this all day long, and I just want to be straight up. This is one of the best resources that I can ever say that we've got for parents out there. If he's got some questions where he needs to go, that's why we're doing this show with Kevin right now, to give you guys a little bit of direction. I'm not an attorney. I'm not an expert. There's certain things I can do. I made this show to get out that awareness and hopefully try to get some resources where you guys can get some direction. There's also the Dad Talk Today support group, where there's tons of other parents that have been through these situations, where people can get in there and talk back and forth to each other. Because I'll be honest, we are losing the war on keeping up with everybody's messages and emails. And a lot of times I'm just not able to see it, guys. But this right here, this is why it's here. So you can ask your questions and we can bring up your comments and I get it right away. Also, if you're talking to your brother or anybody that's watching this show tonight, Kevin, you've said multiple times, if you are watching Dad Talk and you call his office, free consultation.
That's right.
Take that, guys. Free consultation. When I had to go consult with a lawyer, it was $400. And it was not the greatest advice. So to have a show like this where you can ask your questions, and if you need to consult and move it further, guys, please utilize that, because that's why we made it. And I wish something more I could do, man. But Kevin, we get this all the time, and it's like I can't give the legal advice. I'm not the greatest guy on that, and that's why I have you on here.
Yeah. But yeah, we usually say it at the end of the show too. Just tell our staff that you saw us on Dad Talk Today when you call to set up the consult, and there's no charge for the consult. So, absolutely. And we'll help any way we can. A lot of times it ends with, here's what you need to do, X, Y, and Z, and we don't become your attorney, but at least you can get some answers to some questions. So.
Yeah, I mean, I'm so sorry that this is going on, Randall, and tell your brother Doug. You really do. I'm so sorry, but tell them about these resources, and if there is anything further, we'll try our best. Kelsey Kinman said, another dad posted that mediation was required even with the child requesting to change the custodial parent over the age of 14. Is this a standard requirement in Georgia? I don't know.
Georgia. I'm not in Georgia. But I'm not sure. Okay, what I'm thinking is many times there's some judges in Arkansas, and I think in other states too, they try to curb people immediately coming back to court, filing things. And so what they will do, Eric, is put in their orders, you've got to go to mediation before you come back to see me in court. So they want to make sure that they really have a dispute and that they've tried to settle it first before they go back to court. So I think what Kelsey is saying is that the child, there's really no reason to go to mediation because the child is saying they want to go live with the other parent. So why are we going to go to mediation? Why is that required? Well, no states that I know of will let just a child decide where they're going to live. There's a big misperception out there that once a child turns 12 or 13 or 14, I hear all different kinds of ages, that once they turn that age, they can decide where they want to go live. And that's not the case. It is a major factor that the judge considers, but the judge has the final say so on where that child's going to live. So it's sounding like if that's what's in your order, you probably have to go through the mediation first. Maybe you can get it settled at mediation, but if not, then you'll probably have to file with the court. As far as whether that's a standard requirement in Georgia, I don't know. To me, in Arkansas, it's different by judges. It's not a statewide mandate.
Yeah. I think we got a question like this not too long ago. Maj Hudson said, Are lawyers obligated to ensure that the mental state of the other party is okay before they sign an application for enforcement action be taken against the other parent? Is that part of the code of ethics of lawyers?
I don't think we've had that question. That's an excellent question. And I think what is being asked is, if I'm hired and we need to go after this other party to enforce something, either an order that's been entered or whatever, do I have a duty to make sure they're mentally okay? Um, there's no way to really investigate that. I will usually talk with my client, or my client will advise me, look, you need to know that my ex is bipolar, or they have some kind of issue that makes them mentally unstable. There's not a lot we can do about that. We usually will just go ahead and file, serve the papers on the other party, and then let them get an attorney. But there's not a lot we can really do to try to investigate that, because of HIPAA regulations and everything else. Investigate the mental state of the other party. Now, if it's known that the other party is incapacitated in some way, or disabled, mentally disabled to a point that they don't really know what's going on, I'll usually ask my client, is there a guardian involved, or someone like that? But other than that, we just don't really encounter those things until after we've served them with papers.
Mark Jason Sandoval said, why is it that I got 50-50 custody, and since she quit her job before temporary orders, I have to pay her $800 because that's the difference from what she would pay me, and I would pay her for regular custody. It's so unfair, and my attorney says there's nothing I can do. Please answer.
Well, there's a huge discrepancy in income, and a lot of people will agree on a 50-50 custody situation, that since we're each having the child or children half the time, then there's no need for child support because we're each incurring expenses equally. But the courts a lot of times look at that as, well, if there's a difference in income, then we need to, between the parents, then we need to equalize that somehow. And the parent that makes more money is going to have to pay some to the parent that doesn't make as much money. Now, he's talking about quitting her job before the temporary orders. And I think what he's alluding to is trying to make it look like she has no income or little income so that she can get more child support. You can try to show that she's working below capacity, or that she should have been employed and could be employed for a certain amount of money. Certain different judges look at that differently, but you're entitled to show that information, that, look, judge, she's got a bachelor's, or she was working for this amount of money for so many years, then all of a sudden doesn't have a job conveniently. When we go to court, you need to what's called impute that income to her and make her, it should equal out somehow. So that's the only way I know to fight it. And if the temporary order's already been entered, then you're going to have to fight that out at the final hearing.
Absolutely. Kevin, you're going to love this next name on here. Up Your Food Game on YouTube.
Anyway, already like him.
Waiting to use it. He said, evening, gents. I'm watching events unfold on the Chad Reed case, and from what I see from here in the UK is that there may not even be a prosecution. This should be a case to change family law, in my opinion. I mean, to see that this case is being watched over there in the United Kingdom is crazy, man.
That is crazy. Well, it hadn't been decided yet. And as far as murder, there's usually no statute of limitations on that. So they can file that quite a bit down the road. We talked a little bit about this, was it last night or the night before last, when we were talking about the Chad Reed case, that my opinion is that the prosecutors are gathering around, looking at the evidence, and they're wanting to make sure they've got a pretty rock solid case before they arrest him. And I also said, and I still feel the same way here 48 hours later, I'll be very surprised if he's not charged. That to me is going to cause a huge uproar. It's already turned political on, self-defense cases and that kind of thing. And as you said, it's kind of being dovetailed on the Rittenhouse case, and it's two totally separate situations. And it's a shame. It needs to be looked at in a vacuum, and it's in its own case, and not be politicized or anything else. And so there's, I mean, give it time. I still think the prosecutors are going to charge with something.
I hope so. I do believe there was a lawsuit filed today. Don't quote me on that, guys, but I did see some articles going out that they have put a lawsuit out. As we get updates on that, we'll bring them to you. I think they made a group on Facebook called Friends of Chad Reed, where you can go and get updates on that. So you guys be looking out for that. Mike Scarborough said, has there been any family court judges who have been arrested and jailed for malfeasance that you know of?
Not that I know of. No, I can't think of any offhand.
He said, how many cases ever get in front of the judge?
Well, most of them. Let me take that back. About 90% of cases settle, and that includes cases that look like they would never in a million years settle at the very beginning. So when you start a lawsuit, there's a 90% chance that you're never going to have an actual trial because it'll be settled one way or another. So I guess I would say around 10% of cases end up in front of the judge for the judge to decide, or a jury.
Yeah. Juan Garcia said, can we sue guardian ad litem attorneys or opposing party counsel when things go south with primary custody parent?
Probably not. To sue them, it would be for some kind of malpractice. You usually have to show that the case would have turned out differently or that you would have prevailed except for the malpractice that happened. Generally it's very hard to do. Now there's always exceptions, and it depends on what happened in the particular case, but generally that's not an option.
Yep. Cheddar Man, we're getting some food stuff in here. I've been wanting to use that. Sorry. He said, what is the best way to go about talking your baby mama to court for equal custody?
Well, if you're somewhat on speaking terms, I usually suggest trying to talk first about it to get an idea. And some people say, oh man, I'd never in a million years. And I get that. A lot of people are to the point in their relationship that there's no talking, or to try to talk about it just turns into an arguing match. If that's the kind of relationship you've got, or it's gotten to that point, then you're just going to need to go to an attorney about it. But if you can talk civilly about things, either talk to them or put it in an email, put it in something that is thought out, and get your thoughts together, and put in there the reasons why it's best for your child or your children, and why it's going to work out, and why you're wanting to do it. And you can approach that first. The next best way, in my opinion, is talk to an attorney and see if the attorney, if you don't want to talk to them directly or can't, or it's going to be a bad situation, talk to an attorney about it and see if an attorney will write a letter for you and say, look, I was approached, I've written these letters before. I was approached by so-and-so. They just wanted to broach this subject with you about joint custody, and here's why, and here's the reasons. And they don't want to have to go to court. They'd like to work this out if possible, and get with us if that's something you're interested in.
Chris Alexander said, in regards to the mental state question, I am currently in court and evidence was presented, and the court accepted a mental evaluation order and filed the court order for the other party. Can you help elaborate what that could mean?
I'm trying to understand what he's saying here. A mental evaluation order. Does that mean like a commitment order? Chris, if you can define that a little bit.
Yeah, brother, I'm having a little hard time kind of picking up on it, but we've got a little bit of time still left in the show. If you'll get that down there for me, we'll make sure we get you taken care of. Joseph Anthony Amoroso said, my parental alienation family court case has turned into parental kidnapping, as my ex-wife has just moved 2 states away without any notice. 4 years into the family court process, and after being brought up on contempt for not complying, which she is back to doing again, What normally happens in this type of case? What happens to the child if he is severely alienated and the custodial parent goes to jail?
Well, this sounds really familiar. Moving 2 states away. Your question is what normally happens in this type of case. It depends on how upset the judge is with it. What we do is present everything we can to the judge to show, Judge, you are the gatekeeper here. You're the one with the hammer, and we need you to use it. This other parent is not, it's not getting through to them that they've got to comply with these orders. You put these orders together for a reason, and they're to be complied with. And I'm doing it. I'm complying, but the other parent is not. Now she's taken off 2 states away with my children. We need some relief. We need something to be done about this to get it stopped. And that's all you can do is impress on the judge that contempt needs to be found here. This person needs to be reprimanded, and this needs to stop. That's the best thing you can do, and it needs to be sooner rather than later, because as you go to your last question there, the severe alienation, that's just going to start getting worse. You've got to try to get a handle on that and start curbing that sooner rather than later.
Holly Gager said, has it become common these days to have finalization of an order take longer than the county's written legal time frame?
It can happen. I think I know what you're talking about, Holly, is that most counties and most states have guidelines. They're not black and white as to when a judge should get an order entered and get it finished. So your question, is it becoming common, I guess, to go beyond that? I don't know if I'd say common. It's not uncommon. It does seem that there are certain jurisdictions where the orders take a little bit longer. I'll tell you one of the coolest experiences I had. This was very interesting, and this was a temporary case. I had a case in north of Chicago. I think that was Lake County. I can't remember the county. And I went with local counsel up there, and we had a hearing. Our side and the opposing counsel, we made our arguments to the judge, and the judge made a ruling and said, okay, here's what we're going to do. Here's my ruling on these 5 or 6 issues that we had. And so I kind of took notes on what she ordered, and we were done, and I was leaving. And the other attorney said, whoa, come back here and let's do the order. In her court, you went to the back of the courtroom and you wrote down in handwriting, both attorneys, what she ordered. We made sure we had the verbiage right and wrote it all down, and then took it back to her, and she signed it before we ever left court. And I always thought that was fantastic. And on temporary orders like that, you don't want to do it after a long contested final hearing when there's a lot of emotions and that kind of thing. But the vast majority of temporary hearings could be handled that way, and you get your order done right then and filed. And I always thought that was pretty cool.
Chase Dutton said, how would you talk to your ex about her starting to pay child support?
Very carefully. That's a tough little conversation to have. It depends on your relationship with your ex. If you communicate regularly and you can feel like you can have a civil conversation about it, then you need to bring it up. The question is going to be why now? So you need to have a reason for that. Have the child support laws changed? Has your income changed? Has her income changed? There's a lot of factors there, but you've got to have your reasons together. Most people are not going to want to have that conversation with their ex, and they're just going to need to go to a lawyer and have them hash it out.
Milton J. Orlana said, went to court for false allegations of rape against my daughter. Of course, they were false, and commissioner told ex that she was coaching the kids. Why isn't she charged for perjury? I am now requesting 50-50, and our evaluator said I should be getting kids from Saturday to Tuesday. I'm going to be honest with you. I mean, in the cases of perjury, and if you got to prove that this was false, what do you feel about 50? Well, you go ahead and answer this question. I'll ask that in a second.
Well, the perjury is, we get to ask that a lot. And well, that person just lied on the stand. yes, that can happen, but the vast majority of the time, a prosecutor is not going to charge someone with perjury. It just does not happen. Now, we will do what's called impeaching a witness, and that basically means showing that the witness is lying on the stand. And a lot of clients will say, so then it doesn't matter. Well, yes, it matters. That judge is up there trying to judge everybody's credibility, and that includes every witness that's up there. So if you start to show these string of lies that they've made in the past or on the stand, that kills their credibility. When you start talking about false allegations of rape, that's about as serious as it gets. And you've got to really analyze what was said. And if this child is sticking to their story, the commissioners made a finding that the ex was coaching the kids. But unless that child gets up there and says, "Okay, now I was lying, and mom told me to say this," which doesn't happen a lot. It's hard to get that kind of definite information. It's hard to pin down enough, because now you're putting the child in the situation of them having to go to court, and you're pointing at them and saying that child is a liar. And it gets really touchy to try to push something like that.
Yeah, I guess my question was going to be, in cases like this, if you've proved that these were false allegations, I don't know that I'd be doing 50-50. If somebody actually has that mentality that they would make allegations such as that can be completely, it can completely ruin your life. I don't know.
There was a judge that has retired recently that was local, and he'd been doing it a long time. And I had a case where I represented the father. We knew it was false allegations that were and we knew mom was coaching. And we ended up settling that case down the road. But at the temporary hearing, the judge said, "Sir," pointed to my client and said, "if I find these allegations are true, you're going to be in a lot of trouble, and you're probably going to have a lot of criminal liability coming your way. So I'm just letting you know that." And then he turned to the mom and he said, "Ma'am, if I find out that you coach these kids to say this, I'm taking them out of your house, and they're going to dad." And he made no bones about it. And like I said, we ended up settling that case, and the allegations went away and all of that. But I really respected that judge for having that position about it, because it is that serious, and you're harming someone's life by alleging one of the worst things you could ever allege about somebody is that they've done something like that to their child, and it can't be taken lightly. And I think too many times it is.
Yeah. All right. Looks like I was trying to wait on that other question to come back in from Chris, but I never saw it. This would probably be your last.
Will you put it back up and I'll answer it as best I can?
He said, in regards to the mental state question, I am currently in court, and evidence was presented, and the court accepted a mental evaluation order and filed the court order for the other party. Can you help elaborate what that can mean?
Now, I'm wondering if it was like a mental incompetency order. They found the person mentally incompetent, which is a lot of times like if they've had a mental breakdown or they're a danger to themselves or others. I don't know if that's a mental commitment order. That can mean a lot, Chris, if that's what you're talking about. That really shows instability mentally for the other parent, and the judge is probably going to really go your direction. If you're talking about a mental evaluation that someone did, not necessarily an order, it was like a report that was entered, that's also going to help you. I think if this is on the other parent and you're trying to show that the other parent isn't mentally stable enough right now to take care of the kids, either way, that's going to help you.
Yeah. We got one from Juan Garcia. He said, how would you suggest going about submitting a complaint to the bar and actually being successful with an opposing counsel attorney, abusive and unprofessional?
Well, Juan, that's something that I was going to bring up, but try to keep my answers as short as I can. When we went on this before, you were talking about suing. The other option is filing a complaint. If you think there's been some kind of unethical activity, you can go to the State Bar Association for your state, and usually they have online forms you can fill out, and you just type out on there a description, a narrative of what happened and why you feel like there was an ethical violation, and then they'll usually investigate that. They'll look into it for you. So that is another option.
Yeah. All right. Looks like that brings us to the end of the night. We got another one down. Guys, I hope all of the information tonight is somewhat helpful. We do this every 2 weeks. We'll be back again. 2 weeks. We'll do it on Monday next time. And you guys make sure to come in here. And if you got some more questions, put them down in the comments. Kevin, if there was anybody that would like to reach out to you for a consultation or would like your services, how could they do so?
They can call us at 479-434-2414. That's 479-434-2414. My main office is in Arkansas. We have we have 3 offices now here in Arkansas. But I do take high conflict custody cases anywhere in the country. I get admitted to practice in your state and work alongside your local attorney. And so if that's something we can help with, that's parental alienation cases, false abuse allegations, anything along those lines, we can help with that. We also have a lot of great information on our website. It's kevinhickeylaw.com. That's kevinhickeylaw.com. We have a lot of articles on there, blog posts. We have a bunch of buttons on the first page you go to that you can choose pretty much whatever topic you want. But we have alienation information, CPS information, all kinds of stuff on there to help you out.
Absolutely. Guys, make sure to tune into that. Like he said, he's got some amazing resources over there on the website. And again, we'll be back in 2 weeks. We're getting near the beginning of the year. How much longer do we got before we go to the trial of John Mast, Kevin?
John Mast, the Jim Brashear's trial is still set for the week of March 21st. There's always a possibility of continuances. We have not heard of one yet, but that's where it stands for now, and it's set for that entire week. I know I'm going to be out there. I think you're going to try to come out too if you can. So yeah, and I'm sure we'll be talking more about that as it gets closer.
Got one last minute one in here. I'm going to bring it real quick, okay? Because it's a new viewer, and appreciate you for being here. His name is Tyson Ashton. He said, "Hey there, guys. First time listening to this show. Great show, by the way. Question is, my ex called CPS accusing my 14-year-old son of sexually abusing my younger son and me of neglect, and CPS found absolutely nothing. Could I ask for primary custody now? And is this is just one of many issues?"
It depends, and it depends on what those other issues are. That's a pretty serious thing. It depends on how involved the ex was in the coaching. You know, sometimes a child will say something to the parent, and the parent justifiably gets concerned and calls. Other times, the parent just totally takes the situation and runs with it, inappropriately and is trying to alienate. There's a lot of factors there, but something like that, if you can show that the parent was involved, is definitely something to consider on a custody case.
All right, man. Hey, Tyson, thank you for being here, guys. We'll see you again in 2 weeks. Kevin, thank you so much.
Thanks, man. Hang in there, brother.
Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also super chats, patreon.com/dadtalktoday, and other ways you can support our channel. Thank you for being here, and we will